Starts, I will ask you to start. Yeah, madam, now the recording is on. Thank you very much, Dr. Prachi Pandey ma'am. Dr. Prachi Pandey ma'am is Deputy Director for Startup and Entrepreneurship with University in Vadodara. Madam is a renowned practitioner of patents, and we are really grateful to you, ma'am, for this lecture. And thank you very much. You can begin, ma'am. Thank you very much.
Okay. So, very good afternoon to all the innovators who have gathered here to discuss something about innovation and IPR. So, I extend my warm welcome to all the innovators and especially to Shri Tinu Bale sir, who has given me opportunity to interact with you all. So it's really such an interesting topic, is like innovation and IPR, how they are linked with each other and how we as an innovators can protect our innovations through the intellectual property rights. So let's start. Sir, can you please shift to the next slide?
Ma'am, can you see the?
First of all, I'd like to let you know is like Government of India has given lots of benefit to the startups. So because government wants that as an academician, as a natural person, we should protect our innovations in a very better way. And so that's why there are a lot of opportunities, a lot of privileges being extended by the Government of India to the startups. So first of all, it is a 80% rebate on the filing fees. Every natural person or a startup or even an educational institutions are eligible for a 80% discount in the patent filing fees. That is, we need to pay 1600 rupees for our provisional and as well as the complete specification filings, as compared to companies who are paying about 3 times, 4 times extra. So, and yes, as an innovator, if after filing the patent, if we wish to publish it,
sorry to interrupt you, ma'am.
Publication.
The lowermost part is not visible. So, Mr. Tinu, that some icons are coming up. Can you just remove them through the more action?
Okay, wait 1 minute.
So you can do the full screen, so it will be visible to everybody. And yes, for any innovator, they can avail the facility of expedited publication by filling the Form 9 at a very normal fee of 2500. And yes, they can also avail the benefit of faster examination process that could be completed just within 105 days. So that is a benefit, that is a facility extended by the Government of India to encourage the startups. And also there is a provision that when an innovator can feel that the innovation is not working out, or they cannot come to a conclusion that they had earlier expected, they can even withdraw their patent application. And there is a provision of 90% refund for the application withdrawal. And another advantage is that when some innovator register a company, the tax exemption for 3 years that has been extended now for 4 years in the recent budget. So no tax payment need to be done for the 4 years after incorporation. But before that, doing this is the benefit that I have just discussed. Now we will think about what is innovation, what is invention, and how IPR is linked to innovation, and how we can protect our innovation by the way of intellectual property rights. So in the next slide, the basic comparison between invention and innovation is there, where we can see that whenever we like generate an idea for development of the product for the first time that has been never been done before, we are inventing something. But if we are making some technical advancements over the existing prior art and making it more innovative, then we are producing an innovation. So innovation is adding value to the already existing products. So nowadays, as an innovators, we all are mostly doing the innovations as compared to invention. But yes, if we have generated a new idea and developed a product for the first time, it become an invention. So scientific skills are required in invention, but for an innovation, technical, strategic, all kind of marketing skills are needed so that our product could be a implementable product, commercializable product, which has some commercial value in the market. So in this way, basically in R&D, inventions are being carried out, and innovations, we are actually being preparing a tangible product which has a market value. In the next slide, we will see how invention is being converted to an innovation, because a small wheel is being converted to a full cart whenever we are developing it in the form of using the idea to develop in the form of a proper product which has a commercial value. In the World Wide Web, internet can be called as a invention. But later on, the use of internet for several social media platforms that have good commercial values, such as Facebook, WhatsApp, these could be called as an innovation, and they're generating many revenues. So innovation is basically a revenue generating tool which can help in the growth of the GDP of the nation. So I think the slide is switched to the next slides. So yes, and after the next slide, there is a description about innovation and IPR, how they are linked with each other. So the world we live today is driven by innovation. So research and development are now going global. Now we are doing a global scale up of our product. The patent is definitely a territorial right, but for getting a patent, we should have a worldwide novelty. Means like it should not be reported anywhere in the world, because now in the era of internet, anybody can search and can find out what is already reported. And there is a chance or opportunity, we can say, that some copying of the product might take place. So for novelty criteria, the patent office always checks through the worldwide databases. So before filing patent, it's very important to do exhaustive patent search through the worldwide databases such as WIPO sites, and can generate an analysis report, which is giving you the idea whether the patent is there in India or world or in which country. If it is reported anywhere in the world, it is not novel. It is in the public domain. Publications, prior use, prior reporting, all are the criteria which destroys the novelty. So that's why it is important that whenever we do innovation, we have to first protect it by filing a provisional patent application, so that after that it is protected. Means once we get the priority date, we can say that we can go and publish, we can go and do any conference proceedings, even if it is in public domain, even if it is in publication, our rights are protected. Because in India, there is a first to file system. Those who file first will get the rights first. So as per KPMG survey, in 2018, India is the third largest tech innovation leader in the world. And gradually we are moving upwards. So there is a great assurance that creative works, innovations are capturing our Indian markets, and our students are a major contributor of that, who are developing many innovative products in their labs, and now they're scale up in an industry to develop some product with a commercial value. So basically there are three ways by which innovation could be protected. These are patent, trademark, and copyright. So all three have their own pros, because they're different prospects. Why? Because they cover a different era of the intellectual property rights. As we can talk about the patent, copyright, and trademark, we can have a comparison of that. So in comparison, we can see that copyrights are basically for the matter which are literary matter, software materials, or dramatic material, or any kind of poetries, or even standard operating procedures of any equipments, which are fixed in the form of a paper or a recording. Unless until it is fixed, then it is not possible to be copyrightable, because there is an idea expression dichotomy. So idea must be expressed and fixed, then we can go for copywriting it. Trademark is very important for the firms who have their own trademark which are different from each other because the trademark give them a unique identity of their product that is different from all others. And there are some criteria like your trademark must not be explaining your product, and it should be a coined word. It should not be very similar to anything that is existing. Patent Act is specially for product and process, which is a tangible product or a novel process. Copyrightable materials we have already discussed. Patents are specially for novel products, but trademarks could be shape, even color, odor, noise, slogan, anything which can give an identity to the brand is the trademark. And yes, why? Because people may not get confused between the innovator product and some other product, and for that the brand is very important for that. That's why trademark. What I suggest to the innovators present here today is like always go for a trademark search before deciding your company name, before deciding your product name, because if it is already in public domain, it will be difficult. Even if whenever you are preparing your website, you just search for it, because if you are being similar to the already reported websites, this could be a case of cyber squatting. So cyber squatting may be innocently done, but it is a kind of offense. So whenever we prepare any website or think of giving some name or slogan or color to our product, we should first do a trademark search. So under particular class, we can have a list of trademark reported in the office of the trademarks, and in that we can find it. We have to be very unique, and then we have to register our trademark. The validity of copyright, as we know, it's 60 years after the death of the author, and the lifetime of the author is there. So it lasts up to the lifetime of the author plus 60 years. So next generations could also be benefited from the copyrighted materials. Trademark validity is for 10 years. That has to be renewed further. So after 10 years, everybody has to renew it to claim it again. Patent has a time duration of 20 years. This is a territorial right. So once we patent something in a particular country, we get the monopoly right of marketing in that country only, not any other country. But yes, for getting the patent granted, it must not be reported in any part of the world, so that it should be reported as novel. Symbolic representation we always see as a small c for copyright, and a trademark is represented as TM whenever in registration process, and whenever it is done, then R. No symbolic representation for the patent. In the second slide, we will see some more like differentiation among all of the three. So this is copyright secures the creative or intellectual creations, trademarks secure the brands, and patents secure the innovations. Rights are exclusive rights, definitely for all of them. For copyright, exclusive rights over the author set. Trademark gives the right, complete right over the said mark, whether it is a color mark, odor mark, shape mark, anything. And the registration process for trademark usually takes about 12 to 18 months. Whereas in patent, the registration process takes about 2 to 3 years whenever done through normal process. But even in 6 months, a patent can be granted if we go through expedited process of publication and expedited examinations. So even in 6 months, because once you file your provisional and you are taking about 12 months to file complete, then it will be long. But suppose if your product is complete and you are filing directly a complete specification, so after that you can immediately request for the publication, that is through expedited process, and for that you can fill the form 9 with a fee of 2,500, and your patent application will be published in just 15 days or maximum 1 month. And once it is published, we can file for request for examination, and this examination process through expedited way can be done through filing the form 18A and by paying a fee of 8,000. After that, normally patent office takes about 1 month to 2 months maximum to examine the patent applications. And after examination, they will generate a first examination report. And if we are able to answer the queries raised in the first examination report within 15 days or 1 month, how much time do we need? After that, it could be re-examined, and again if hearing is needed they will call you up, but maximum time we can expect is like 6 to 7 months could be there for the grant of patent. So within such a short span somebody can be a holder of a patent right. That's true, but through normal processes it takes about 2 to 3 years for publication, examinations and all. So but even after there are 17 years left behind for marketing of the drug as an exclusive monopoly rights. In copyright, there is no provisional, we have to directly file. In trademark, we require a trademark search and we have to submit a trademark search report also. In patent, after provisional, we have to file the complete specification within 12 months. If we, like suppose our product or the, like our experimentation is not complete and we need more time. So normally if we don't file within 12 months, our complete specification, application is deemed to be abandoned, but there is an option of post-dating it. Means before expiry of 12 months from the date of filing or provisional, if we request the patent office for extension of 12 more months, it could be granted, and then the date of filing of the complete specification becomes the date of filing of provisional, and we get 12 more months to file our complete specification. So suppose if we need 2 months, 3 months more, we can file within 12 months at any time in between. So that is a provision which can give us to like post dating of the our patent application. But yes, there is a disadvantage that we will be lagged behind by some months. And if somebody is working in the same domain and filing the patent application like before us, because now we are lagging behind. So in India, there is a first to file system that another person may become the holder of the patent right, because we can lose our rights. The next part is our types of patent application. So types of patent applications are basically in India, we file the ordinary patent application, that is our provisional and complete specification. Beside that, we can file for convention application under the Paris Convention, through which we can simultaneously file in many different countries which are a part of the convention, and we can get the benefit of the same priority date. Divisional application is an application. Suppose in a patent application, we have filed 3 or 4 type of inventions, closely similar, true, but in a single patent application. So suppose we feel or somewhere controller objects that this is not a unity of invention, means your application consists of more than one innovations. So in that case, they may direct that you have to divide your patent applications into number as many as numbers of the innovations, and can file separate patent application for each of the innovation and also pay the separate fees for them. So this might be the case. So yeah, we have to carefully examine it, like our like innovations must not be different from each other, and we are filing a single patent application, that will be objectionable actually. So that's why divisional application is divided applications. Application for patent of addition is a great advantage given to the innovators whenever they, being a scientist, they discovered that after filing the patent application and after even the grant, they feel that they have actually modified or added some more improvement in their existing patent application. In that case, they can file the patent of addition. That will be like continuation with the main patent application, and they will expire with the main patent application. So the tenure of patent will be the same as the main patent, but this will be as an added application. So this is a very good advantage that like even after the grant, they can file a patent of addition and can take the benefit of the improvement. So during experimentation, many times we feel that we have filed the patent, our patent is examined also, it is granted also. Now, how can I add the improvements that I have done in the recent days? So file a separate patent application as a patent of addition in reference of your main invention, main application. And this will be accepted by patent office if it is acceptable. And because patent office has to examine it, like whether it is really a improvement or it is just some addition. So it should be a improvement with addition in that way. So if it is like it can satisfy the controller, they can accept it, and yes, the tenure of the patent will be the same as the main patent application. Another option is PCT national phase, through which we can get a discount of 90%, as India is a developing country, and through which we can claim the priority rights simultaneously in 152 countries if we wish to enter in those countries, and we can claim a single priority date of our international application filing date. So that is a big advantage through PCT route, that is Patent Cooperation Treaty. 152 countries together signed an agreement that once the innovator in any of the country files an international application in the site of WIPO or in their national patent office, if it is a receiving office, then within 31 months in India and within 30 months in other countries, from the date of filing of the first application, if they enter the national phase, they can claim the priority date as the international application date. So definitely we can enter in all the countries simultaneously and can claim our priority date or the priority rights based on our international application. So this is a way by which the foreign applications can be done. And yes, I wish to let you know there is a provision of 90% reduction of fees. So normally we say that it takes about, it's very costly affair, normally everybody say, but I tell you that it's not so costly, it's very economical, because in every fee you have to deduct 90%, because India is a developing country and the WIPO has given this advantage, this privilege to India. So we have to be aware of such things, because our government, even the world, is so much cooperative for innovators that they are supporting them so well. So why not to take the advantage of all these facilities? So it's there. Now I'm emphasizing something about the patent, so that we can be a little bit aware what to be what is patentable, what is not patentable, and I'm giving you some brief examples so that you can correlate with your own innovations, and it could be beneficial for you. So the next slide is about what are the criteria for patentability. So we all know that patents are the rights granted to innovators that allows them to exclude all others from making, using, and selling their invention for 20 years. But for that, we have to qualify the nonce test. So nonce is new, novelty. U is utility, industrial applicability. N is again non-obviousness, and the last one is statutory subject matter. So whenever we filter out our product through all these four meshes, finally we can get a product that is patentable. So what is novelty? In the next slide, you will see what is novelty exactly. So in the next slide, there is an understanding novelty. So novelty is based on prior art search. Our product must not be claimed prior to the date of filing of patent application. Date of filing means the first date on which we have filed our provisional application. And we have got an application filing date and number, and the date, not only date, the time in minutes and seconds also. So if somebody has filed even 1 second later than you will have the more rights for that patent as compared to others. So suppose because ideas come in everyone's minds, and they may think in the similar manner. But what is important, that if some idea comes in our mind, and if we are sure, like within 12 months, my idea could be converted into a tangible product, then I should go for a provisional patent filing. Because patent office search the prior art before the date of filing of our patent application. So what they search? They search for papers, they search for conference proceedings, publications, the earlier patents, because they shouldn't be claimed earlier, they shouldn't be published earlier, and they shouldn't be in public use. I'm talking about public use. But suppose if I'm preparing a concrete and I need to test the strength of concrete, how will I test? I will make some bricks or some pavements out of those concrete and allow a few selected people who are my trial participants to cross over the pavement. And then I will check the strength of my pavement in that way. If I'm doing in this way, like a very like small area with a restricted number of people, then this is exempted. So I can do this without losing my novelty. But suppose if I find that yes, it has a good strength, so now we will supply to all the government departments, and now I will use it for public use. So in that case, novelty will be destroyed. So any experimentation or like any trial done to validate our products will never lose our novelty. So prior public use is prohibited, but prior experimental use is not prohibited. So in that way, we can be sure about our novelty. This is a basic criteria on which the objections are normally raised by the patent office during grant. So we have to be, that's why I suggest the innovators, like before filing a patent, they should go for an extensive patent search through the proper site of WIPO. WIPO is such a worldwide database of patents, because every patent filed in any country will be become a part of the database of WIPO. So suppose today I have filed in India, after 6 weeks, you can see your patent on the site of WIPO also. So likewise, in any country, suppose some patent is filed, it will be visible on the site of WIPO after 6 weeks. So you can have an idea how many patents, what kind of patents, what is basically have been done in the past. And the next step in the next slide is related with that. Once you figure out what is reported in the past, what has to be done? You have to do a long jump. What does it mean by long jump? Is like we have to be more and more technically advanced as compared to the what is reported. If we are making a little changes and filing a patent, then it may not be acceptable to the patent office, because the patent office will say this is a very obvious innovation, and no, this will not be acceptable because it is not inventive. There is no human intervention involved. It is just a very simple kind of product that has been prepared. So that's why inventive steps are must. You have to be very inventive, and it has to be proved. So, but it need not to be much complex. Complexity is not a criteria of being innovation. So in the next slide, I'm giving you a very simple example of a coffee collar that has a patent, because this coffee sleeve is just a very simple innovation made up of cardboard material, but this is very useful. So that's why this is not a frivolous invention. This is actually a useful invention, and that's why, but it is very simple, not at all complex. It was considered patentable. But suppose if I'm replacing a material with a harder material in order to produce a more wear resistant product, it's not, actually it's very obvious. If it is hard, so definitely it will be wear resistant. Then again, I'm adding some black color to an object to improve heat transfer and making it like I have prepared a product and coated it with black. So it will transfer the heat more effectively. So this is not an invention actually. This is totally obvious. Doesn't have any inventive step. So just for simplification, I have added this slide. And so in this way, and the third part I wish to discuss is industrially applicable. Industrially applicable means what? Like it should be capable of being made or used in an industry. So what can be made or used in an industry is which have a good reproducibility. Means suppose today I have prepared my product, and within like every day or intraday, any day, there is no variation in the quality of my product. Every day I'm able to produce the same kind of product with the same quality parameters. Just for example, the Pizza Hut pizza or the like McD's burgers all have the simple quality. This is just for a very simple example. Whenever we talk about a business product, actually commercializable product, the quality of the product must have the same every time. So this is a criteria which is very important for qualification for a patent to be granted, and also to capture the market. Another thing, the S part of the nuns was the statutory subject matter, that is what is not patentable exactly. So the first thing is what is not an invention. First thing is that which is frivolous or obviously contrary to well-established natural laws. So if we are making something which is very innovative, definitely, but if it is against some natural law, it is not patentable. Just for example, in 1986, some innovator have prepared a dimple drill. So those people who were unhappy because they were not born with dimples could use this apparatus and get their dimple drilled. So as they always wanted, but this was against the natural law because people were not born with this, and this was considered not patentable. even if it has a lot of inventive steps. So we have to be very particular about it. The next example of this is a case study where somebody has prepared a timepiece having different kind of arms for hours, minutes and seconds, and divisions into 10 parts, 100 minutes, 100 seconds. So they were actually playing with the time that is already have a certain cycle. So this application was also rejected. So such kind of thing, or even the perpetual motion machine, which can give you output without any input. So such kind of things are frivolous, which are against the natural law. So these are not considered to be patentable. The next part is whenever an invention, in the next slide, whose commercial exploitation or use could be against the morality or public order, or it is a prejudice to human, animal, or plant life or environment, it is not patentable. Suppose any gambling machine, and yes, one more thing, if some kind of genetic manipulation which is leading to a product which can be harmful to the society. So that's why there is a system whenever some scientists do some genetic recombination or do some biotechnological product development through the gene transfer or some gene splicing, then first of all, such kind of microorganism, if they are developing, they have to be first deposited in a lab for security, and then patent has to be accepted. So that is a way through which the biological materials, patent or innovations can be carried out. So yeah. So in the next slide, again, one more example is the terminator technology. Gene splicing, gene transfers are not patentable, as well as the sex determination technique to find out because this will facilitate a female feticide and also can enhance the environmental pollutions. Anything which is against the public order or morality are not considered to be patentable. Another section says about in the another slide is if any scientific principle is being discovered, or any living or non-living organisms which are already existing in nature is being discovered, then those are not patentable. So discovery means what is already there in the nature. So if we discover any star, discover any gene, discover anything which was not earlier known, this is a discovery, not a patent. A very landmark case of Funk Brothers seed versus Kalu inoculants. What they did is they made a composite mixture of 6 strains of bacteria which used to inoculate the leguminous plants, and these bacteria were nitrogen fixation bacteria, and as a composition they were actually doing it more effectively, but it was rejected. Why? Because they said that this is just a mere admixtures and all of already existing bacteria which are already in the public domain. Everybody knows about those bacteria. These are existing in nature. There is no human intervention. But suppose those bacteria, if some scientist can make it by recombinant DNA technology, then those bacteria are patentable. So if I make something in my lab which is not in nature, definitely I have introduced a lot of human intervention, and that's why my product is patentable. So yes, so in the next slide, again, some more example about this is suppose Archimedes principle, superconducting phenomena, these are all not patentable. But if I make a apparatus or I use a method using such principles, such products are patentable. Just for example, property of certain material to withstand mechanical shock. A rubber material can withstand the mechanical shock. That is a property, and somebody has established a scientific principle about it after a lot of works in the lab. But this is a principle that this material can withstand the shock. So it is not patentable. But suppose if I make a railway sleeper coach which is made up of that material which can absorb the shock and can make the ride very comfortable, then that railway sleeper coach or that berth will become patentable. So we have to make a product using any idea, any scientific principle, whatever it has a merits, it is not patentable unless until we convert it in the form of a tangible product. So this is important example for that. In the next slide, we'll see, suppose some basic example is like a new generator. is a technical solution, it is patentable, but the mathematical formula for the generator, not patentable. Again, if you are using the generator on a bicycle, again, more merits on patentability. Or suppose if we have prepared a method for manufacturing the generator and that method has never been done earlier, I can go for a process patent. So through process patent, definitely we can get the rights. But any scheme, any formula is never patentable. Then the another part is like section 3D, which normally have the pharma people are very much aware of, because in before 2005, this section was not there. And once this section was introduced, especially in pharmaceutical field, there are a lot of innovations took place, because now nobody can just file a patent by simply making a similar kind of product and can launch in market, because patent office says that any salt, ester, ether, metabolite, solvent enhanced products, crystalline forms, all are the same. Unless until you can prove that they have enough efficacy, enough benefits, enough bioavailability, means like enough effect in the body, all drugs are considered to be the same. So this is the region when nowadays every company is focusing on R&D, because now nobody can just launch a product as such. So in the next slide, there are some case studies of section 3D that I'm not emphasizing much, but yes, we can, if somebody is interested, they can go through the Roche versus Cipla, Ganciclovir case, then your Novartis versus Union of India, the litigation which took about 17 years in Supreme Court, and then finally rejected based on the ground. So we cannot make as such anything. We have to do a lot of innovations, especially in the pharma field, to get a product granted. So that's why this is the most difficult domain to get a product granted. Now,
ma'am, could you explain, could you please tell in detail about these examples if possible?
Okay, fine. Are you from pharma field, ma'am?
Yes, ma'am, that's why.
Okay, fine. I will be happy to say about those things.
Thank you, ma'am.
Okay, fine. Let's discuss. Okay, so the famous patent cases of section 3D. So what happened exactly is like a Swiss drug maker Roche. So what they did, they launched a drug that is anti-HIV drug Ganciclovir. So earlier, like crystalline form of the known drug Ganciclovir was already there. They have launched Valganciclovir. What was Valganciclovir? It is a crystalline form of the known drug. So after making the crystalline form, they claimed that they have increased the bioavailability. And you know how much bioavailability? They have increased 40% bioavailability. But Chennai Patent Office rejected patent claim in 2015, saying that just 40% bioavailability and claiming of reduction of side effects are not enough. You have to be give you more bioavailability. This is somewhere a subjective case, because somewhere a 40% bioavailability should be accepted. But at that time, the section 3D was at boom, and patent offices were rejecting it and saying that this is the same. This is the same as earlier. What did you do? So it was rejected. Another time, I want to talk about Hoffman-Roche versus Cipla. What has been done? So Roche erlotinib. So earlier, gefitinib was there. Gefitinib was for launched by Cipla. Roche has made a polymorph of gefitinib. So polymorph can be generated by temperature fluctuations, like you can raise and lower down the temperature, freeze, thaw, and some polymorphs could be generated. So this polymorph, that is erlotinib, that was claimed for pancreatic cancer, was launched in market by the Roche. So what happened? Earlier, Cipla had the monopoly right in market for lung cancer, also for pancreatic cancer, and they have launched the drug gefitinib. Now it was a threat to Cipla, because Roche was also entering in market with erlotinib, which is just a polymorph of gefitinib. But people will buy both of them, because Roche was claiming that this is a better one. This polymorph has more efficacy. So definitely the market capture of Cipla was going lot down. So what was done? Cipla opposed it. Cipla filed an infringement suit and said that they are selling the same drug that they had launched some years earlier. So what happened? Then these infringement suits are normally filed in High Court. So High Court allowed the Roche patent. High Court said that no, Roche is not infringing. Patent Office has already allowed it, so that's why Roche has launched the product. High Court also allowed Roche patent. Then Cipla filed SLP in court. Again, they fought. After 9 years of court cases, why? Because this patent office, why they allowed erlotinib? Because there were significant ground. Polymorph was actually more efficacious, so patent office granted. But Cipla, definitely it was in the condition of threat, so they tried to block the Roche by filing the infringement suit. But see, after 9 years of court cases, court couldn't come to a decision because they were considering that erlotinib is also novel. Cipla's gefitinib also exists. So both should coexist in market. High Court said that. So between two pharma giants, there was a settlement took place in 2017, and now both are in the market together. So in this way, one pharma company kills the market of another pharma company by doing such kind of innovations. So yes, but there are a lot of examinations by patent office. Unless until it is very efficacious, it cannot be granted because there are almost 60%, more than 60-70% rejections and 20-30% acceptance. But where to bring the new molecule in then? Now molecules are limited. Everybody is doing some innovation by solubility enhancement or crystallinity introduction or some kind of polymorph generation. So that's why such kind of fight are very probable in Indian pharma market. Another is Novartis versus Union of India. Novartis has launched a product that is beta crystalline form of imatinib mesylate. So beta crystalline form is again comes under section 3D. Indian Patent Office rejected it. There was a 7 years long litigation fought by Novartis in the Supreme Court. But Supreme Court said that no, Patent Office has taken a right decision. This is just a beta crystalline form. Under section 3D, it must not be granted as a patent, and you have to withdraw this. So based on section 3D, it was rejected because that beta crystalline form was not couldn't prove their efficacy and bioavailability to a maximum extent. So again, patent office is very particular about it, how much bioavailability you have achieved. So nobody can just do the solubility enhancement and file a patent. It will never be granted. Believe me, it is never granted unless until you do the kinetic study and prove that it is more bioavailable. So that's why I always say the people that once you do solubility enhancement, I want a patent, think till your kinetic study and blood analysis and prove your bioavailability. Then only think for a patent. So I think I'm proceeding now to cover some more things. So in the next slide, we say about whenever something is a mere admixture. Mere admixture is like whenever we mix something like paracetamol and ibuprofen, combiflam, very common drug we used to take. It's not patentable. Why? Because it is just the 500 mg paracetamol and 250 mg ibuprofen mixed together. But suppose if we mix and dose of each is reduced because of that mixing and synergistic action, then this combination become patentable. Suppose paracetamol become 400 mg, ibuprofen 230 mg. So definitely we can overcome some side effects because of this combination and synergy. So, but it was not there. So combiflam is not patentable. ORS, very useful product. Everybody has taken it. Glucose, sodium chloride, bicarbonate. But what is this? This is just a mixture of all the components who have their individual role. Glucose has their individual, sodium chloride, electrolyte replenisher, potassium chloride, again that potassium replenisher. There is nothing synergistic in combination. So such products are not patentable. Actually, anybody can mix them and get a patent. What is human intervention then? So patent office want to see your hard work in that. That is not here. So that's why it is not patentable. In the next slide, again, it very similar. Whenever we rearrange or reassemble something, it is not patentable. Because suppose if we are making some component together and making a product which is a combination of all of them, it's not patent. Just for a very simple example, umbrella and a torch, umbrella and a fan, because they are working separately. We open the umbrella and switch on the fan or switch on the torch. But suppose there is one silver lining here. If we attach a sensor that lights the torch whenever we open the umbrella. So normally during rains, it becomes little dark, and whenever we open the umbrella, the sensor itself lights the torch. Then both the components are helping each other. And in this way, they are actually working together to make a single unit invention. In that case, it is patentable. So it has to be interaction among the components, not just the assembly or arrangement among the components. This has to be taken in account for most innovators, because this is a mistake normally we do. We have to be attach it in some way so that they can support each other to make it patentable. So always there is a silver lining in all the sections. We have to critically analyze all of them. So there are many ways by which these like silver linings could be leveraged, and yes, we can establish some kind of synergy. So I am going to the next slide. That is section 3I. What is not an invention? So any process, medical, surgical, curative, any process is not patentable. Why? Because if any surgical process is patentable, any doctor can get the patent of that, the treatment becomes very costly, and that is totally not allowable in our scenario. Any medical device is highly patentable. Just for example, this patent of bunny syringe of US with this patent number, because normally kids are very afraid of being vaccinated in their earlier age. So the scientists in US have developed a syringe and attached a small bunny just before their needle. So whenever this bunny approaches the kid laughs. And whenever bunny, this syringe gets inside the skin of the kid thinks that the bunny has given him a bite. And then again laughs. And the vaccination process became very easy. So such kind of product, which can really solve some problem that is already existing. Everybody knows that during vaccination, kids cry. So if they can solve such problems, this is a very useful product. It has a great value. But yes, there are enough scope in this also to have introduction of some of the innovative steps. And yes, we have to look after what we can, how we can improve the already existing innovations. In the next slide, also the same way. In the next one, any plant or animal, section 3J, are not patentable. Why? Because any microorganisms, because where they are existing in nature, but suppose if we have developed something in the lab, if we have developed something in the lab which has never been done before, such as recombinant DNA technique, this ship, Dolly ship, also became patentable because this is now a product. This is not already existing in nature. So already existing plant animals, definitely not. But if you are producing it in lab, it becomes patentable. Now, there are many examples related with that. I'm coming to section 3K in the next slide, where a mathematical or business method or computer programs, algorithms are not patentable, they are copyrightable. But you can use such algorithms to prepare a product. Algorithms are a great innovation, like a way to innovate. I can say that this is a tool to innovate. So algorithms are being used for compression of the voice to be effectively transmitted via 2G, 3G, 4G, and this product become industrially applicable. And yes, these have a patent. Google filed patent in Kolkata Patent Office 2014. Use of computer program to develop computing device. Oracle filed patent application in Kolkata again in 2010. System and method for preparing compended blocks using algorithms. So use algorithm, use softwares to make a hardware, make a product, and go for patent filing. Patent office will welcome your product. So in this way, we can go for that. Then again in section 3I, any literary, artistic, musical work, method of playing games are not patentable. Section 3N, any presentation of informations. And yeah, the last one, topography of integrated circuits are not patentable. They are have a separate act, that is Semiconductor Act, through which these are protectable. Because such chips are used in almost all kind of mobile devices, even cars. So they are not patentable, but they are protected through Semiconductor Act. And section 3P is like about any traditional product which is already in public domain, and you are just making a mixture of them, such as Chyawanprash or your Patanjali products, basically because they are just a mixture of taste. But suppose if you are preparing a good ointment, a good nanotechnology based ointment, or some penetration in containing ointment, it is about the ointment, not about the traditional APIs. So in that way, you can get the patent of your product. So this is the way we can have some silver linings through which we can use it to file our patent application. And yes, section 4 is about atomic energy. So inventions related to atomic energies are not patentable, but they are under Atomic Energy Act 1962. So these are some of the way I try to explain you. So yes, if you have any questions, you can ask me. Thank you for such patient listening.
Ma'am, thank you very much. Indeed, a great presentation by you, and we are really happy to have you with us at Adani Institute for Education and Research. I would request participants, if they have questions, quickly we can take the questions because we have to move to the next session as well.
I have no question. We can move ahead.
Thank you, ma'am. No questions.
Okay, okay. Thank you. Thank you, Prachi ma'am. Thank you very much. Thanks a lot.
Thank you so much.
I will get in touch with you again. Thank you, madam.